Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I am here every Sunday on these stations from 8 to 9 a.m. to bring you, the landowner, the information that you need regarding natural gas development here in Pennsylvania. And want to welcome to our Tioga County listeners. Started to do the show in several, I think actually 3 stations that cover the Tioga County area just this past week. So very excited about that. And one of the things, quite honestly, one of the things that I wanted to do is I really want to get information. We want to get information out to everybody. But, I see areas that I find that people are being presented with agreements. And in this particular case, in Tioga County, I think that companies are presenting landowners with very, very favorable company agreements, and particularly not just limited to, but in particular, these pipeline right-of-way agreements. And it was very important to me to try to get a hold and get information out to as many people as possible in this area, because I assure you, ladies and gentlemen, that although companies are presenting these company-favored agreements all across the state all the time, these are exceptionally slanted to the company. They are very bad agreements, in my opinion, for landowners. Very bad. Not enough compensation. Generally, in most cases, half, and sometimes much more than half, the compensation that we're seeing offered in other places in the state. And people are signing really bad agreements. And there's a lot of reasons. I talked last week about it, but there's a lot of reasons. But people are signing bad agreements, and we need to turn this around. We need to bring Tioga County and other counties where people are signing bad agreements, but we want to bring Tioga County around so we're getting you guys better agreements. You need to have the best possible agreement. You have your neighboring counties, 1-2 counties away, signing routinely for double the compensation, sometimes more, also limiting to, for example, one pipeline. And then, say you have an offer in Tioga County, for example, of $16 a foot for total compensation. Well, in Susquehanna County, you may have an offer for $32 a foot. $32 a foot. And in Susquehanna County, your offer may be for each and every pipeline installed, you would get an additional $32 per foot of pipeline installed. So, quick little example, 1,000 feet at $16 a foot would be $16,000. The company in these typical agreements that we're seeing in Tioga County, the company can install 2 lines or 3 lines, but let's just stick with 2. So making it simple, 1,000 foot of right-of-way, company puts in 2 lines. They pay you $16 a foot across the board, not for each line, but just $16 a foot. Well, now here you go. Easy math here. I can even do this one. We got $1,000. No, I can't do it. We got 1,000 feet at $16 a foot. So we got $16,000. That's what you're getting in Tioga County in this example. Let's move over to Susquehanna County. $32 a foot is your offer, plus you get $32 a foot for each line installed. $32 a foot, 2 lines installed equals 32 times 2 equals 64 times 1,000 feet, $64,000. So, Tioga County landowner, you get $16,000. Susquehanna County landowner, under the same scenario, gets $64,000. 64. Pretty remarkable difference. We're just talking money. We're not talking about other terms and conditions to protect you, the landowner, from liability, to protect you, the landowner, from operations that you didn't anticipate, going much wider than what you maybe originally thought. I assure you, ladies and gentlemen, there are so many loopholes in these agreements. And when you're first presented a pipeline right-of-way agreement, you're looking at this in this vacuum. You're hearing, oh, yeah, we need to get royalties. We need to get this gas to market. The price of gas is low. You're hearing that dialogue directly to you. But I assure you that that dialogue has been occurring across the state for a very long time. You have to understand that we have this base of information. We have many other counties that we can look to as to how this evolved, and we went through the same thing. Susquehanna County, a great example. A few years back, companies were saying $15 a foot, that's all we're going to pay. We want to be fair to everybody, $15 a foot, $15 a foot. Well, now, routinely $30 plus a foot. Routinely. We need to make sure that we change that. We don't want people to sign bad agreements. We want to make sure that you're aware of what your options are, that you can decline these agreements. And, people fell for it in Susquehanna County, and they signed at $15 a foot. And the company said, we want to be fair, we want to be fair, we want to be fair, this is all we pay. And then, a year, 2 years later, 6 months later, whatever the time may be, their neighbor signed at double that, triple that, quadruple that. It just depends on what the scenario was. So please, we want to get this information out there. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday. Just started running in Tioga County on 3 stations last week. So if you miss any of I'm doing the show. Oh, that's the other thing. 5 years. We just hit our 5-year anniversary of doing All Things Marcellus last week. So you can go to my 2 websites. I really encourage you to go there. Not just because I want you to go there and hire me. Okay, I want you to go and look and read. Go to my main site is pagasleaseattorney.com. That's pagasleaseattorney.com. Check out there. We have the radio shows archived. I think there's over a year of shows up and archived. Then also, just within the last 2 weeks, released our all-new revamped pipeline site, pipelineattorney.com. Like I said, I've done pipeline agreements now with over 50 different companies. I don't say that to try to brag, to say, oh, geez, look how important I am. I'm saying that to give you some perspective of the experience that is out there, that the prior dealings, that how these companies operate. I've represented every type of landowner. Landowners are saying, some of them I have to talk into, hey, I really think you should consider asking more money because they're ready to sign anything. But at the same time, I have other landowners who, have false expectations as to what we're going to be able to do. And then we need to bring those landowners back and say, hey, look, here's what I think we can do. Here's what I don't think we can do. So, we've had people who fought things out to the bitter end. We've had people who signed early. So, we can look at this, get good information, and give good advice on how is the best way to proceed. We need to know, can you say no to this agreement? Can you negotiate? And we know, thankfully, what you can negotiate, but we need to do that evaluation. And you as the landowner, please, you cannot rely on the gas and pipeline company landman. Again, you cannot rely on the pipeline company landman to tell you what your rights are, to tell you what your leverage is in negotiations. You cannot rely on them. They work for the pipeline company. Their job is to get your signature. Their job is not to give you a fair deal. Their job is not to give you a better deal than what their employer wants to give you. You need to know that. The landman, I don't care how many gifts they bring you, bread, pie, donuts. The more they bring you, the nicer they are, the more you should be concerned. The more you should be really looking at this. I don't care, the landowners say all the time, oh, he's so nice, or she's so nice, he's so nice. Again, yeah, they're not having somebody come out and just start push you around. They're going to come out, they're going to be nice, they want to befriend you, and they want you to sign an agreement that their employer wants you to sign as a landowner. So please, you cannot, whether you talk to me, you talk to somebody, you cannot rely on the pipeline company landman to represent your interest and to tell you what your rights are. It's unbelievable, but you cannot do it. What's unbelievable is too many people are falling for it, thinking that this guy or girl is their friend who is out there fighting for them or trying to get them terms. You can't rely on the pipeline company landman. Why? I'm going to say it. Because they work for the company, not you, the landowner. All right. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Sorry, I didn't plan on going down that path. If you're a regular listener, I know it sounds like a broken record, but it drives me crazy. And I'm seeing it all the time now, and Tioga County is killing me because I'm so upset because people are being taken advantage of, in my opinion. They're signing bad agreements, in my opinion. I think it has some weight to it. It's my opinion. And why it has some weight, I've done hundreds and hundreds of agreements, and I'm seeing people sign these agreements, and it just leaves me shaking my head. I want to go and just scream from rooftops out there, hey guys, let's get this information and make good decisions. What's happening is there's these promises of royalties, and people get excited, and understandably so. And then they sign these documents. And what's going to happen is just like in all of these other areas where people who sign bad pipeline agreements really early, they're sitting there years later and still haven't seen what they were promised. And that we've seen it. We're going to see it here. We are going to see it here. There's just going to be a 1 to 2 year gap before you start seeing this disappointment. So please get good information. Okay, so I didn't mean to go down that path so much, but now what I'm going to do, though, I'm going to talk about specific pipeline agreement language, and this is very important, as I say often, whether you're in Tioga County, Bradford, Susquehanna, whether you're in Washington County, Greene County, Armstrong, I don't care what county you're in, it's relevant, but it's especially relevant here today for Tioga County in that area. But I assure you, please, if you're listening, don't tune out, because this is very relevant to everybody, but especially relevant now because I'm going to talk about an agreement, terms, and offers that are being presented to Pennsylvania landowners in the Tioga County area. But the same thing applies in other places as well. So what I'm going to do is after this first break, we're in this segment a little bit short, but after this first break, I'm going to talk about this pipeline. We're going to talk about pipeline option agreements. I'm going to explain what this option is. I've talked about that before, but I want to talk about options, and then I want to talk about some specific terms and loopholes. And I mean, this one, I hate to even call it a loophole. It's a black hole. It's much larger than a loophole. But I'm going to talk about this, and this reason alone, I've made this statement. I said, I will not represent any individual who is going to sign an option agreement from a certain company that's out there. And I'll say, well, if you have an Angelina or a Howard option agreement presented with an option agreement document, I will never represent a landowner who signs that document. I will withdraw as counsel because I believe, my own opinion, that it's virtually malpractice to have a client who's going to sign this option document. It is horrible. I will never, ever, ever represent anybody who is going to sign the document because I am that adamant against this offer. I am Attorney Doug Clark. You're listening to All Things Marcellus. Remember, I'm here every Sunday from 8 to 9 a.m., and I will be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and I'll tell you, I'm picking up some steam here, feeling better, getting my energy going here. It's early, getting my energy up here because I'm getting a little fired up. But a reminder, we just released our whole new revamped. I mean, it's been up, I can't remember when, over 5 years, I think, with the websites as well. Yeah, definitely over 5 years with the websites, but been working on this tirelessly for a while. Go check out pipelineattorney.com. Google pipeline attorney, pipeline lawyer. I think we come up number 1, 2, or 3 in almost all relevant Google searches. So really very excited about that. And you can go there, talk about what pipelines are, eminent domain, condemnation, a lot of great information. And I want to stress that. Information. Get information. You don't have to go and say, go there because you need an attorney. Go check it out to get information. I'm also doing the blogs there that I'm writing myself, obviously, and also pagasleaseattorney.com. So if you miss any of today's show or any show, You can go to pagasleaseattorney.com. You can also go to pipelineattorney.com. We have a link there, and you can go back and listen to radio shows. Really encourage you to do that. Please get information, whether you ever call me. And look, I'd love for you to call me. I'm here. I represent landowners. I love doing it. I want to keep doing it. I'm very happy with what I'm doing. I mean, literally, I love what I'm doing. But I recognize that I'm not going to represent every single landowner, so I want to get this information out to you so you're thinking about it, that you can talk to. If you talk to another lawyer, talk to him about this information. Please be informed, because we do not want to see you sign bad agreements. And literally, landowners, literally have left millions upon millions of dollars on the table because they weren't informed, because they didn't talk to people. Do not be afraid to call a lawyer. Do not be afraid to get information. Do not be afraid to ask questions, because by not doing so, you are going to hurt yourself, and you don't want that to occur, obviously. So again, I'm here every Sunday from 8 to 9 a.m., started running on some news stations in Tioga County. Very excited about that. And because of that, I started running, like I said before. I want to get information out to everybody, obviously. However, I'm really now, especially in these first few weeks, I really want to talk to Tioga County, but again, it applies to everybody. But what we're seeing is areas that are not as fully developed, that are in the early stages of development. We are seeing that, like in Tioga County and pipeline agreements. We are seeing the same thing in 2015 in Tioga County that we saw in 2010 in Susquehanna County, in Bradford County. We're seeing the same thing. And what we found is that over time, you're going to find that, in my opinion, strongly, these pipeline agreements in Tioga County are going to look a lot different, and they're going to be for a lot more money in the future. The problem is the company's trying to suppress that as much as possible, to keep these numbers down as far as compensation as much as possible, as long as possible. The same thing with terms. They don't want to offer you good terms. They want to keep those terms in their back pocket as long as possible, until landowners are forcing them to give them a better market price, a fair, legitimate price for these pipelines. Until landowners are forcing them by exercising their rights, until they start doing that to get better terms, to identify location, to protect themselves from liability, to limit the impact on the property, and to maximize compensation. And here's what I'm saying. We need to fast forward and stop signing bad agreements so that you as an individual are going to get a better agreement, as will everybody in your community. We have to stop this trend of people signing bad agreements. We need everybody to sign a better agreement, and they're signing better agreements across Pennsylvania. That's what I see. So we need to stop that. We need to say, okay, we're not going to let you as a company sign bad agreements for the next 1 or 2 years before things start evening out and landowners start doing better, because they're the landowners who didn't just run to sign. We're going to change that. We're going to fast forward. Instead of having a year of signing bad agreements, we're going to take that away, whether it be a year or 2 years or even more. We're going to go to a point where we're not going to sign bad agreements. So we're going to force you to give the landowner a fair, reasonable agreement, just like we're seeing in Susquehanna County and other counties. So we need to, now look, none of this is specific advice for anyone. We need to understand what your rights are. And if the company doesn't have the right to install a pipeline under the gas lease, and I assure you, there's a lot of misleading statements being made out there by pipeline company landmen saying we have certain rights, where, again, they're not the ones that you should be listening to advise you. They are not the ones you should be listening to advise you. You need to find out, what is the company's authority? How is this going to play out going forward? And all of these promises, oh, we're poor, the gas prices are low, we're real poor. Well, these pipelines are going to be in there for 50, 100 years, or who knows, maybe more. And look, you want to test that? Say, okay, company, you're crying poor, why don't we do this? Let's put an agreement, or let's put a term in this pipeline agreement that says that after 30 years, let's be nice. Let's say after 40. Let's say after 50 years, this agreement terminates. 50-year agreement for a pipeline, then it terminates. And you know what's going to happen? They're never going to agree to it because they know that they fully intend or want the option to go way beyond 50 years. So when the gas prices are low today, let's fast forward 30 years. Are companies going to come back and pay you more money? Well, of course not. It's ludicrous. It's self-serving to sit there and say, gas prices, gas prices, gas prices. Yeah, it can be a factor, but why isn't it a factor in other places where I'm signing clients for pipeline right-of-way agreements routinely over $30, over $60, and in many cases, over $100 a foot? Now, again, I don't want to stress that too much because that's not something that everybody can get, but I assure you I have done many pipeline right-of-way agreements at well over $100 a foot, well over, sometimes hundreds of dollars a foot. But that's about what your specific case is, your leverage, your options, consultation, understanding your rights, and making the best decision going forward. You know, we've done pipeline right-of-way agreements at lower value, but generally speaking, there's a reason, and it's limited. Well, always there's a reason, but because of very limited circumstances of options of what we can do to make this better. But what happens is the company wants to act like you're in that position all the time. And the reality is you're rarely in that position. You are rarely in that position. Some landowners are. We identify where you are. We assess your leverage. Look, go to pipelineattorney.com. I did this section about assessing leverage. One of the most important things on the website. One of the most important things when you're dealing with pipeline negotiations, assessing leverage. And you as a landowner, you're operating in a vacuum, and it's going to be difficult to assess leverage. It's much easier. And again, I'm not saying that I'm this brilliant person. The first pipeline agreement that I did was the first pipeline agreement I did. You know, I didn't know what I know today. I've done hundreds upon hundreds of pipeline agreements with all of these different companies. That has given me such great experience to help my clients, which and to provide this information on the radio, to get this information out there. That's what you need. You need the experience to assess this leverage. And I haven't, I've very rarely, and I've talked to hundreds upon hundreds of landowners, talked to somebody who understood all of this and was able to accurately assess their leverage and have everything kind of dead on. Is it possible? Yeah. But what occurs way more often is a landowner has this belief of what their leverage is or what they lack, and very important, what they lack in leverage. We have a consultation. They then understand, and I tell you, it almost always ends this way of like, wow, I'm really glad that we spoke. I have such a better understanding of what's going on now, what to expect, and what I'm going to do going forward. Whether I continue to represent them or not, and quite often, most cases we do, if the landowner is going to continue with negotiations. There are many times that we have a consultation I do with clients, landowners. You sign up, we represent you for a telephone conference, review all your information, talk about your leverage, talk about my experience, talk about what you may be able to expect, what I'm seeing in your region, what I'm seeing across the state, educating and informing you. Take that opportunity. And then when we talk and say, well, look, you can really decline this. Here's all the different reasons why. And maybe you want to do that. And so we notify the company, thanks, but no thanks, not interested. And that many times can be the end of things and you're done. So a lot of times people are engaging in these negotiations and discussions when quite frankly, they have no obligation to do so. No obligation at all. And once they find out what their rights are, once they understand that in most of these cases, eminent domain and condemnation doesn't apply, once they understand all of those things, they say, you know what? I really don't want this pipeline, and I'm going to say no thank you. And that's the end of it. That happens all the time. So a consultation, and again, I'm not trying to be a commercial here, but I'm telling you, there's so much value to having at least, give us a call, do a consultation, review everything, explain to you my thoughts, my opinions based upon my experience, and then you can decide Do I want to decline this if I can? Do I want to go forward and try to negotiate and make this better by myself, which you can do? I don't recommend it, but you can do that. There's no one that's going to ever stop you from doing that. Or do you want to move forward with me representing you, which you can do that as well? Or you can go hire somebody else if you want. But understand what your rights are. The company landman, pipeline company landman wants to have that dialogue with you, wants to have that relationship with you, wants you to think that they're representing a representative of you. They're your friend. They're the nice guy. They want to get you royalties and they want to get you money. But they're standing there within their hand is a document that is entirely company slanted that is doing you no favors. No favors here. No favors. And the second you start asking for things that are reasonable and fair that many other people are getting, you may find that they're getting rejected. And you say, well, company guy is my friend. He's a landman. He's trying. He can't get him. Okay, well, that's good enough. I'll go ahead and sign. Or my neighbor signed it. All right, I'll go ahead and sign. I talked all about that last week. I'm not going to keep going too far, but just remember, just because your neighbor signed a bad agreement does not mean that you should sign a bad agreement. Just because your neighbor signed a bad agreement doesn't mean that you should sign a bad agreement. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I promise, going to talk about options and get into some more specifics right after this break here every Sunday from 8 to 9. Be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday on these stations from 8 to 9 a.m. If you miss any of today's show, I have been doing the show. I'm very proud of this. I am. Never thought that I would ever say this, but I've been doing the show now for over 5 years. And so I hope you're getting value from it. It's a lot of times for me, it's therapy. I get the vent from things that I experienced during the week, but very, very excited that we hit our 5-year anniversary. You can go to pagasleaseattorney.com or pipelineattorney.com. Access prior radio shows, check them out. We'll have today's show up and available tomorrow morning, Monday morning, and we'll have an index of saying, what the topics are during the show. Okay, so again, I'm a commercial alert here. I do that sometimes if it's going to be a little commercially, but here's my commercially alert here. So okay, if you have this pipeline agreement, and you're saying, okay, well, I don't know that I want to hire an attorney. I don't know what I want to do here. I would encourage you, give us a call, 570-307-0702, and have a consultation. Consultation to learn your rights, talk about what strengths and weaknesses of the offer are, talk about what other people are doing in your region, what people are doing across the state. And, I said, talk about the strengths and weaknesses. Quite frankly, there'll be a lot of discussion regarding the weaknesses of what you're being offered. So you can contact me, 570-307-0702. I do a lot of these consultations, and sometimes they turn into where the client continues and I represent them and we do negotiations. Sometimes it results in the client saying, you know what? Thank you. I'm glad I know my rights now, and I'm going to just simply decline this offer and say no thank you. And then other times it's, okay, well, now I have this information. I understand. I'm going to move forward either by myself. And look, you can go hire another attorney if you want, but get this information. I really recommend it. It's your option, obviously, but get this information because too many people are signing bad agreements. And you can call me 570-307-0702 if you're interested. Okay. Now I want to talk about, I'm going to talk about this agreement in Tioga County. Once again, it applies more than just Tioga County, but this is where an offer is coming out that many, many people are receiving, and it's killing me. You should see my hands in my head. It's killing me. Many people are signing this, and they're signing it because they're not informed. That's why. That's the only reason that you would sign this agreement, in my opinion, as a landowner, because you're uninformed. And like I said, I will withdraw as counsel. I won't take the case. I will never represent a landowner who signs these option agreements that are being presented in Tioga County. I will never represent anyone who's signing that option agreement. Now, what do I mean by that? Okay, let's talk about options. And do this quick. I've talked about this many times. I'm going to try to do it quick. Okay. Option agreement. What does that mean? Here's what happens. A company says, all right, we're going to put a pipeline, or we want to put a pipeline across your property. Landowner thinks, well, probably this is what they're going to do. They came out, they say, we want to do this. That's what they're going to do. And they make, you certainly believe in these discussions with the company landman that the company is going to install a pipeline on your property or multiple pipelines. So what happens? They come out, though, and they present you with most companies. I said, I've done agreements with about 50 or over 50 companies across the state. And what they do is most of them are option agreements, but they're one document. It's a pipeline right-of-way option agreement. What does that mean? It means that when you sign the agreement, it is not a guarantee that the company is going to install the pipeline. Not a guarantee. It is an option. It is an option for the company, and typically the company will pay you some money up front. A lot of companies will pay a few $1,000s, sometimes more. You always want to get as much as possible, but a lot of times, routinely, $2,000 to $5,000 for signing the option, which generally, in almost all cases, more than covers any attorney fees. So in the event that the company doesn't actually install the pipeline or exercise the option, that you as a landowner still make out because you got some type of payment, you got a good agreement in case the company does actually move forward and install the pipeline. So you're going to maximize your money, you're going to protect your property, you're going to protect yourself from liability, and you also wouldn't lose money in this no matter what, because you've more than covered any attorney fees that you incurred in this negotiation process by the upfront payment. So that's a very important part. I am, believe me, extremely aware and concerned and conscious about the fact that I do not want to have a client who has a legal bill to me and then enters into an agreement and ends up getting less money from that agreement. And then if the company doesn't exercise the option and saying, well, what in the world did I do that for? So I don't want that. No attorney should want that. So that's part of these discussions as well, is saying, okay, look, if we're going to do this, what can we get as an option? We don't want you to lose money. But if we even can't get this option high enough, you still have to then look at, well, do I just want to sign this agreement that's going to leave me potentially wide open for liability to get sued? And even if you didn't do anything wrong, you can still get sued. And then you have to go in and defend and incur expenses and fees, which is a nightmare for you as a landowner, an absolute nightmare. Or all of a sudden, what you thought was going to occur, where the pipeline was going to be in one pipeline, now the pipeline is going in a different area. Maybe now there's going to be items and facilities above ground, valves, pig launchers, receivers, meters, things above ground that you never anticipated in locations on your property that you didn't anticipate and didn't think were going to occur. We need to protect that. I'm Attorney Doug Clark. You're listening to All Things Marcellus. I'm here every Sunday from 8 to 9 a.m., only represent landowners and oil and gas right owners, not pipeline, if you can't tell. Hopefully you can tell, not pipeline companies or gas companies. Okay, so option agreements. What happens? Company comes out. They present you a pipeline right-of-way option agreement, all in one document that has all the terms. We negotiated. We get you all the money we can, protect you the best possible way that we can, and protect your property. That's our goal. The most money and protecting you and your property. Landowners say all the time, it's not about money. I really want to protect myself. I couldn't agree more. I want to protect my property. Couldn't agree more. But if you have an identical agreement and one agreement's for $50,000, exact same words, except the other agreement is for $100,000, well, we're going to sign a $100,000 agreement if you're going to sign. So we want to get you the most money. Whether that's the focal point or the secondary point, I'm always going to work to get you the most money and the best terms. And we'll talk about, how do we do that and what's the best way of doing that. So, okay, company comes out. They present you with a pipeline right-of-way option agreement. If you execute, say you negotiated, you get it to the point where you're comfortable, you execute it. You get a payment up front. Say it's within 30 days. We want to shorten that time period and we want to increase the payment. So you get the payment up front. Now the company has a period of time, whether it be 1 year, 2 years, 3, 4, or 5 years to decide whether they are going to exercise this option, meaning, are they going to use your property? Now, when a company goes to exercise the option, there's ways that they can do it. Generally, it's going to be with some sort of payment and notice that we're exercising this option. It could be notice by starting the work on the property. But what we want to do too is shorten that option frame, time frame as much as possible. Well, think about this. Company guys say to you, we want to get the gas to market. We want to get your royalties. Everybody's signing this crappy deal, but they're not saying that. Everybody's signing this. We want to be fair for everybody. Price of gas is low. Here's my pen. Here, I'm a notary. Go ahead and sign this. Well, that's what they're presenting to you. Now, what's happening is, though, is you're signing an option agreement. How long do you have to decide whether you're going to do this? 2 years? Well, I thought you were in this big hurry, but here I signed this agreement, and you have 2 years to decide whether you're even going to use it. So I may be waiting 2 years before I even know whether you're going to use it. And then in 2 years, what happens? Well, do you just pay me the money? We'll use an example. Say you're paid $2,000 in order to sign the option agreement, and the company will go with 2 years to decide whether they want to even use this. And if they decide that they're going to use it, let's say that they're going to pay you $50,000 in the future. Well, so here we are. You sign it today. Now the company has 2 years to decide, and say they do decide to use it. Now they give you this $50,000. Well, when do they start construction? Do they have 2 years to actually start working, or to only pay you the money? And now can they sit there for another several years with these rights but never even install the pipeline? So then if you say to the company, well, you're in such a big hurry. You want to get gas to market. You want to do this to help me and the company, obviously. But, this all sounds great. You want to do this. Well, how about for this 2-year option, how about we require that you actually have to start installing the line in 2 years? Or you want a 2-year option. How about we make it a year and a half? You're in such a big hurry. Look, if you're out there, these company guys come out there in such a big hurry. They're in such a big hurry to have you sign a document that gives them at least 2 years in most cases or more to decide even if they're going to use this document. So they're all over you to sign in a document that gives them 2 years to decide if they're even going to do it. Then they're only required, in this example I'm talking about, they're only required to give you the secondary payment to exercise the option. So they're giving you $2,000 up front. They give you, say, $50,000 in the future, and that's a high number. It could be less, could be more, but they give you that money for the future. Well, now they may sit there for another several years until they start construction. So what motivated you to sign this, $16 deal per foot, which is unbelievably low in my opinion? Well, what motivated you to sign it? The promise of future royalties. The idea that they're trying to get this gas to market. They want to get you money. That's where the big money is. But you turn around, here you are 2 years out. First off, maybe they don't even use the agreement and all you got was this smaller upfront payment, or they give you this money, the secondary option payment, the bigger money, but you're sitting there now for years longer and not seeing any activity. I mean, look, I have many clients out there in Tioga County. I've represented a lot of people with Shell and people with wells that are sitting out there that are just capped and nothing's happening. Companies want the ability to have you under contract and do nothing with it. They want to have that ability. Now, some companies will get you under contract and do something, but they want to have that ability. All right, you're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can call me consultation anything, 570-307-0702. Look, pipelineattorney.com, gasleaseattorney.com, Google Pipeline Lawyer. Check it out. Visit the websites. Great information there. I'm going to be right back. I'm going to finish up talking about this option. I'll tell you what, I had all these plans to get into some specifics with these agreements, and I know I'm not going to be able to today, but I will in these upcoming shows because people are getting hammered by signing bad agreements, and you're not realizing it yet now because the construction hasn't started and you haven't found out, well, I thought it was going to be at this location. Now everything has changed. I assure you that is going to happen out there, and we need to avoid that. Again, I'm Attorney Doug Clark. You're listening to All Things Marcellus. I'm here every Sunday from 8 to 9 a.m., and I'll be back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can always contact me at 570-307-0702. You miss any of today's show, you can go back at pagasleaseattorney.com, pagasleaseattorney.com. You go to the radio show segment. If you haven't visited pipelineattorney.com recently or pagasleaseattorney.com, go check them out. They're both renovated this year. Pipeline Attorney just renewed, revamped, renovated. Got to check that thing out. Check out the assessment of leverage section on the website. There's a whole section about evaluation of leverage in pipeline negotiations, and it is critical that read it, understand it, give yourself some ideas, things you should be thinking about. Super important. That's pipelineattorney.com. And a reminder, too, you can follow me at Twitter at Doug Clark Law. Check out the Clark Law Firm Facebook page as well. A lot of great information there. But jumping back in, I want to get back into this option because I have a shorter segment here. So, okay, option agreements. Company gives you some sort of money up front. We want to get the highest amount possible, obviously. Then they want to have a time frame, usually as long as they can. Typically, the shortest, typically 2 years. Anything above that gets really concerning. We start seeing 3, 4, and 5 years. Very concerning. We don't want to go more than 2 years. And we want to be shorter than that if we can. And that means that once you sign the agreement, the company has 2 years or more to decide whether they're actually going to use your property, whether they're going to pay you this secondary payment. Well, what do we want to do? We want to get the highest secondary payment as possible, but we have to negotiate the language in the actual agreement. So I'm talking about Tioga County. So Howard Energy presents people these option agreements, but they're separate documents. You get an option agreement, which is a separate document, which that document is just all about saying, here's what this option is that we have. Then you have a pipeline right-of-way agreement as a separate document. But the option agreement, you have to study this thing. You have to study it. Like I said, I won't represent anyone who signs this. You have to study it because what's happening is it's saying that, look, we're going to give you this agreement that you sign this option, and then in the future, if we as a company are going to elect to exercise or to use this option, then you're going to have to sign another agreement, which would be the pipeline right-of-way agreement, which we're not solidifying that it's going to be the same thing that we're giving to you today. And in fact, we're giving ourselves the ability to change. This is unbelievable. To change, to saying that you as a landowner, you agree that if we as a company exercise this option, you will then execute a document that's going to be substantially the same as what you've signed now, the right-of-way agreement that you signed now. But this next part, I mean, I can't. Oh, it drives me insane. Not only that, but it says, and such other customary terms and conditions that are reasonably requested by the company. So you are going to sign a You're agreeing to sign a document that's going to be substantially the same as what you've already seen or signed. Substantially the same. You know, if you know what that is, here's 570-307-0702. Call me and tell me what that is, because you don't know. You have to see what it is. And then on top of that, other such customary terms and conditions that are reasonably requested by the company. Well, what does that mean? What are those terms and conditions? Why are those not all identified and entered into and executed today, not left open in the future? And here's the deal. They always are. They always are. In every agreement that I've ever done, they are. We never have a client agree to sign other documents in the future substantially the same or similar, and other customary terms that we, the company, may request. That is crazy. I can't believe that people sign it, and people are signing it because they don't understand. They're not informed. So if you're given an option agreement, in my opinion, you can't sign it. It's not a good deal for you. That's a terrible deal for you. And the only reason why people would sign, in my opinion, is they just, they're not informed and they're not getting good advice. And it's just part of the reason why I want to get out there and I want to reach out to people. I want you to understand these. Now, look, if you understand, you're educated, you're informed, you understand this, you want to sign it, hey, that's up to you. You can do that. I would respectfully disagree with that idea, but that's up to you. And remember, other companies are not requiring anyone to do this. You're not seeing this. So you're being asked in these cases to do something that, no other landowners that I'm aware of, and I represent, again, hundreds and hundreds across the state that are having to sign this, or not even having, who are approached to sign this type of agreement. That has to be avoided. Now, that's just one thing I'm talking about here. That's one thing. And when I get in these next upcoming shows, I'm really going to start diving into some of these other terms. But here's the thing. What you're being presented in these cases, I'm just going to talk generally for a minute, and I'm really going to get into this in the future. But what's happening is saying, okay, you're going to sign this, and you're going to sign this other right-of-way agreement now, but it can change, which you can't agree to. But it can change, by the way. It can change. Also, the location, that may change. The agreement itself, is it protecting you from liability? If, God forbid, there's an injury or an accident or something occurs in the construction, are you covered? Well, that's fundamental. What company isn't going to give somebody at least basic coverage if the company is negligent? At minimum, if the company is negligent and somebody gets hurt or something is damaged or there's injuries that are resulting of these operations on your property, you cannot put yourself in a position where you may have to defend or pay as a result of any lawsuit based upon something that occurred on your property. You can't do that. And why would a company ever ask you to expose yourself in that way? Why? And look, hey, maybe you have 100 cases or 100 properties. Maybe you have 1,000 properties, 500, and there's not a problem. And all of a sudden on your property, there's a problem. Well, you're the one that has to deal with it. And 999 other people signed this agreement, and we want to be fair to everybody. Well, you did the same thing, and now you're the one named as a defendant in the lawsuit, which you have to at minimum defend and try to say, hey, look, there's no basis to this. In a worst case scenario, there's ever some sort of judgment against you. A worst case scenario. So the idea, again, just because your neighbor or other people in your area sign bad agreements, sure in the heck doesn't mean that you need to as well. There is no obligation that you need to jump off the bridge because other people jumped off the bridge ahead of you. It's just no reason for that. All right, so that we're talking about the option here. Okay, well, and a lot of agreements are options, but I'm telling you, do not agree to a separate option agreement. You cannot leave this open-ended that things can change in the future. Another thing, you cannot, and I talked about, you have to have liability coverage. You have to have liability coverage. Very basic. And look, most companies offer it, but you need to look to make sure. Now, they don't offer you the best, but you need to make sure that you have it and you have adequate protection. Adequate protection. These are the most basic principles. Another thing, you must know, where is this pipeline going to be located? Where is it going to be? You cannot leave them blanket authority to move this right-of-way and easement all over the place. And I assure you, please pay attention to this. Everybody who signs a map, just because you signed a map showing where that right-of-way is going to be does not mean that that's where it's going to be. Doesn't necessarily mean that. I assure you, I talk to people all the time who sign pipeline right-of-way agreements who thought that the location was going to be at a certain place, and it gets shifted or moved. Think about this. What happens is you sign an agreement. Company goes out, you say, yeah, here's what I'd like it. I'd agree to it here. I agree to it at the border of my property. I'll agree to it if you install it at this section. They say, okay. They give you a map and say, okay, here's where here's what we talked about. Here's what we want to do. Then you go ahead and sign it. Well, then the company goes out and say, well, we went and we did some wetlands delineation. We did some other environmental reviews, and we can't put that pipeline where you want it. So we're going to have to move it to a different location. And you say, whoa. I agreed to the pipeline here. And they say, well, and it's not going to be the same guy because they don't want to do that. So now these people say, well, no, you agreed that this was the preferred location. Depending upon the language, we have the right to move it if we want, or we have the right to move it and you can consent to where we're moving it, but you cannot be unreasonable and withhold your consent or delay it. Very common tactic, ladies and gentlemen. Get in location, put it on a map, get the landowner to sign, have the ability to move it, and even if you get approval, so a lot of times the landowner has nothing to say about it, but they'll present it to the landowner and say, well, here, we want you can have mutual consent if we need to move it. And what happens is they know darn well that they're going to have to move it, or they've done nothing ahead of time to determine realistically whether there's wetlands or whether they're going to have to move this pipeline. So what happens is now they go to move it. They got you as a landowner stuck because if you say, I don't want to move it there, they say, well, you're being unreasonable because there's wetlands and we can't construct it there, and you're stuck, and we're going to put it where we want and try to stop us. You can't let that happen. We're just scratching the surface, ladies and gentlemen, just scratching the surface. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I will be back next Sunday. 8 to 9 a.m. Check out PAGasleaseattorney.com, pipelineattorney.com, and have a great week, everyone.